You've just been hit by a truck and now everyone's asking the same thing. Who was at fault? Your mind's racing, but all you can remember is the sound of impact and the blur of headlights. But here's what most people don't realize. The clearest evidence usually shows up right away. And if you know what to look for, it can change everything. I'm a Tennessee attorney, John Griffith, and in this video, I'm going to walk you through the exact signs that prove the truck driver caused the crash even before the police report is filed. So you don't get blamed for something you didn't do, and the defense cannot rewrite what actually happened and get paid what you deserve. Start with what you can see right now. The easiest place to start is the obvious stuff, the rules of the road. Ask yourself, did the truck driver break a clear traffic rule? Examples include speeding. Did they run a red light? Did they fail to yield? Were they following too closely? Did they make an unsafe lane change? Did they drift out of the lane? Or did they turn too wide without clearing space? These are not technicalities. They are often the simplest way to establish fault early because they match what witnesses saw, what a dash cam recorded, and what an officer may write in the crash report. If you remember anything specific, lock it in. The truck was weedy. The truck never braked. The truck merged into you. The truck ran the red light. Those details become powerful later, especially when the other side tries to rewrite the story. And if you are able to do it safely, take photos at the scene, lane positions, skid marks, debris trails, damage angles, signage, and the sight lines. In truck crashes, the angle of impact tells a story all by itself. Look for signs of distraction or fatigue. Here's how truck cases are different from regular car wrecks. Truck drivers are held to tight schedules. They drive long hours, and fatigue and distraction are two of the most common reasons these crashes happen. So ask, did the truck driver look tired, dazed, confused, or slow to react? Did you see a phone in their hand? Did you notice the truck drifting again before the crash? Did they brake late or never at all? Even if you did not personally see the driver on the phone, that doesn't mean it did not happen. A good investigation can look at phone records, dispatch messages, GPS pings, and onboard communications. And fatigue is not just a vibe, it ties into a real paper trail. Hours of service and logbooks can reveal the true story. Truck drivers are subject to federal hours of service rules. The big idea is simple. A fatigued driver is a dangerous driver. For many property-carrying commercial drivers, the rules limit how long they can drive within a work window, including an 11-hour driving limit within a 14-hour on-duty window after required off-duty time. That matters because if a driver was pushing past the legal limit, skipping breaks, or driving longer than allowed, it supports a strong argument that fatigue contributed to the crash. And modern trucking often involves electronic logging devices, or ELDs. If the driver is required to keep records of duty status, federal rules address those records, and the ELD rule applies to many drivers who must maintain those logs. What does that mean for you? It means fault may be proven with data, not opinions. If you suspect fatigue, you want your attorney looking for the logbook or ELD data, the dispatch schedule, delivery windows, and any pressure from the company that pushed the driver to keep moving. Do not ignore maintenance and equipment red flags. Sometimes the driver is not driving crazy. Sometimes the truck should not have been on the road in the first place. Bad brakes, bald tires, underinflated tires, faulty lights, steering issues, worn suspension, trailer problems, load securement issues. If you saw a blown tire, sparks, smoke, grinding, or the truck struggling to stop, say it early and say it clearly. Those details can point to negligence by the driver, the trucking company, or the maintenance provider. And here is a key point. In many truck cases, the driver is only one piece of information. The company that owns the truck, that maintains it, inspects it, and schedules the driver can also share responsibility. So when you're thinking, was this truck driver at fault, you also want to think, who put this truck on the road in this condition? Follow the money and the control. Who else had responsibility? Insurance companies love to keep the case narrow, about one driver or one policy, one quick settlement. But trucks often have multiple responsible parties, such as the driver, the trucking company or motor carrier, a maintenance contractor, a shipper or loader if cargo was loaded unsafely, a broker in certain situations, a manufacturer if a defect played a role. Why does this matter to you? Because it changes what is possible. It can change how fault is proven, because one party may have records another party does not. It can change the amount of coverage available. It can change how hard the defense fights, because large policies come with aggressive defense tactics. This is one reason truck cases feel like a chess match. If you only focus on the driver, you can miss the bigger reason the crash happened. The police report and witnesses are not optional. If you want to know whether the truck driver was at fault, do not rely on memory alone. Build support. The crash report matters because it locks in basics. Who was involved, where it happened, roadway conditions, and often the officer's initial assessment. Witnesses matter because they are independent. They can confirm the truck drifted, ran the red light, merged without space, or followed too closely. If you can, get names and contact information at the scene. If you cannot, your lawyer may be able to locate witnesses through the crash report, 911 logs, nearby businesses, or other investigative tools. And if you have dashcam footage, preserve it immediately. Do not edit it. Do not trim it. Save the original file and back it up. The truck's electronic data can make fault crystal clear. A lot of commercial trucks capture driving data that can help reconstruct what happened, including speed, braking, and other pre-crash information. People call this black box data, and you may hear terms like ECM, EDR, or onboard systems. The reason this matters is simple. Drivers sometimes misremember information. Companies sometimes minimize information. Data does not get emotional. If the driver says, "I was only going 45 and the data shows a much higher speed," that is a huge credibility shift. If the defense claims you cut in front of him, but the data shows no braking until the last second, that supports the argument the truck driver was not paying attention or was following too closely. The takeaway is not that you personally need to get this data yourself. The takeaway is that you need to act quickly so your lawyer can demand it be preserved. How Tennessee comparative fault changes the fight. Here's where people get blindsided. In Tennessee, fault can be shared. A trucking company will often push a narrative like, "You stopped too suddenly. You changed lanes without signaling. You were speeding. You were distracted. You were in the truck's blind spot." They are not doing this because it is true. They're doing it because it is effective. Under Tennessee's modified comparative fault system, adopted by the Tennessee Supreme Court, if your share of fault is equal to or greater than the defendant's fault, you can be barred from recovery. And if it is less, your recovery is reduced by your percentage of fault. So your goal is not just prove he was wrong. Your goal is prove his mistake was the main cause. This is why evidence matters so much. The more objective proof you have, the harder it is for the defense side to blame you. What you should do next to protect your case. If you think the truck driver was at fault, here are the next moves that protect you. First, get medical care and follow through. Truck crashes cause serious injuries, and the gaps in care are one of the first excuses insurance companies use to undervalue claims. Second, write down what you remember while it is fresh. Where you were, what lane, what speed you were traveling, what you saw the truck do, what you heard, what the driver said after. Third, gather documents, crash report number, witness contacts, photographs, tow and storage receipts, and every medical bill and record you receive. Fourth, be careful with recorded statements. The trucking insurance company may call fast and sound friendly. Their goal is to lock you into wording that they can use later against you. Fifth, talk to a Tennessee truck accident attorney quickly, especially if you have serious injuries. In Tennessee, most personal injury lawsuits must be filed within 1 year, which is a very short deadline. Even if you never file a lawsuit, that deadline shapes how fast your case must be built. And finally, if anyone is pushing you to settle early, treat it like a warning sign. Early money often equals cheap money. Quick reality check. Fault is not a feeling, it is a file. Let me give you a simple way to think about this. If you're trying to figure out whether the truck driver was at fault, you are really building 3 buckets. Bucket 1, what rules were broken? Traffic violations, unsafe driving, failure to yield, speeding, lane departure. Bucket 2, what proof exists, such as witnesses, dashcam, police report, photographs, scene evidence. Bucket 3, what the truck data says, logbooks, ELD, scheduling, GPS, and onboard driving data that shows speed and braking behavior. When those 3 buckets line up, truck driver fault becomes much easier to prove. When you only have 1 bucket, the defense has room to argue. So here's the bottom line. You can often tell the truck driver was at fault by looking for clear traffic violations, signs of fatigue or distraction, maintenance issues, and then backing it up with witnesses, the crash report, and electronic evidence. And the reason you need to take this seriously is because trucking companies do not treat these cases like normal fender benders. They move fast. They protect their driver and they shift blame. If you are hurt and you want to protect your claim, do not wait until you are overwhelmed. The earlier you act, the more evidence you can preserve, and the harder it is for anyone to lowball you or blame you. And speaking of lowball offers, that is exactly what we're covering next. Watch my next video, 5 tips to stop insurance companies from lowballing you after a car accident. It will show you how to protect your words, your evidence, and your settlement value before the insurance company decides what your recovery is worth. See you over there.